Let's do this thing. Good afternoon, everyone. Welcome to the first hour of the Employer Handbook Zoom office hours. I am Eric Meyer. I am a partner at FisherBroyles. I am also the publisher of the Employer Handbook blog. And for those of you who aren't watching this in real time at 12 o'clock on Friday the 26th, you may be watching this on YouTube. Yes, we are recording this. I remembered to hit record. And while you're watching this, and before you forget, give a like to this video and subscribe to the channel. We love having you, and we love getting the word out to other people who may not know about the Employer Handbook Zoom office hours. But today, I am fortunate to have two fantastic partners alongside me today to present. We're going to go in terms of seniority at FisherBroyles, in terms of the introductions. So, Amy, you've been in FisherBroyles longer than both of us combined. So why don't you introduce yourself and tell everyone who you are?
Eric, you have a job on the bar mitzvah circuit if the law thing doesn't work out.
Thank you.
So I'm Amy Epstein Gluck. As Eric said, I am his employment law partner at FisherBroyles, and we're so excited to welcome Simone to our firm. I've been at FisherBroyles for 5 years, which seems like a lifetime, but it has been an amazing 5 years. I'm an employment counsel for the firm, which means I tackle all the issues a lot of you tackle in your workplaces, except for a law firm. I co-author the employment law blog for FisherBroyles, and I handle employment law matters on management side. I work with HR all the time. I work with small business owners all the time. And my goal is really to just help make a workplace a better place, right? Prevent problems before they become bigger problems, and really just help companies comply with the law. I also handle business litigation matters, and I'm currently coming to you from sunny Florida with my parents. And we're all vaccinated, don't worry, including my dad, Larry.
Hi there. Larry.
Thank you for having me.
Thank you, both of you, for joining us.
We're thrilled.
And now to our newest partner who, what do you have, 2 weeks under your belt now at FisherBroyles, Simone?
2 or 3 weeks, yes.
Welcome, Simone. Tell everyone a little bit about yourself.
Absolutely. So welcome. Thank you very much for including me in this program. And I am on the West Coast. I practice law in California, Oregon, and the state of Washington. I am also an employment partner. My second hat and my second practice area is data privacy. So many times those two areas overlap, and I love tackling those issues. I love that Amy described herself as a problem solver, because that's how I see myself as well. It is much easier, as many of you know in this field, it is much easier to prevent problems when you get any employee issues or questions that might arise. Certainly during COVID, everybody had to learn and constantly pivot to adjust to the situation. And so I think it's really great to do preventative work. I am outside counsel for many companies, specifically in the healthcare sector. And then I also litigate, which is, of course, when things didn't go the right way, and I come to the situation on the tail end. I'm certainly also there to help, but I prefer it for you, for anyone that has a business, to be a helper on the front end and not the back end.
That's the plan, to keep people out of trouble, and that's what we're going to try and do today.
That's right.
But here's how we're going to do it today, folks. We're not going to do it by giving legal advice. Amy's a lawyer. Simone's a lawyer. I'm a lawyer, but don't get it twisted. All right? We're not your lawyers. Although I see some clients on here. For the next hour, we're not your lawyers. Okay? We assume that every question you put down in the chat box, and please use that today, because we'd love to answer your questions without saying it depends too much. But we assume that all those questions you're asking are hypothetical ones that you're asking for a friend. Okay? So we're not creating any attorney-client privilege, and we're not giving legal advice. This is free, folks. Clients pay us to give legal advice, right? And we don't want to take anything away from your lawyers, okay? they probably want to get paid too. So no legal advice today. But what we are going to do is we're going to try and hit as many privacy, vaccine-related topics that we can. And to kick it off, let's do something basic. And I guess I'll throw this one out to Amy. Amy, what can we ask employees about COVID-19? Let's just keep it very basic. Like what types of questions can we ask?
You know, we say that that's such a basic, topic, but really I hear all the time from non-employment lawyers and company owners and HR directors that they're still confused about this issue. So I'm so glad you started there, because we get so far into the nitty-gritty that, we forget about these basic things. So what can you ask employees about the coronavirus, about COVID-19, especially at this point in time, right? We've got vaccine rollout, things are moving. You can ask an employee if they are vaccinated. Okay, let me say it again. You can ask an employee if he, she, or they is vaccinated. Okay, that's it. Okay, if you just ask that question, Disabilities Act, and Simone will correct me if I'm wrong, but I don't think I am, and it's not going to implicate HIPAA. Okay, so that's number one. Number two, you can ask for proof that an employee has been vaccinated. Same qualification. Don't elicit any medical information about a disability, and as Simone will tell you, keep the employee medical information confidential. So you can ask if someone's vaccinated, you can ask for proof of vaccination, okay? You can ask employees who are physically entering the workplace if they've been diagnosed or tested for COVID-19, if they're experiencing symptoms, or if they've had exposure. I want to qualify that by saying, if they're entering the workplace, you can ask that. If they're teleworking, you cannot. There is no business reason to ask an employee who's teleworking. You can ask employees to take their temperatures and screen themselves for COVID daily before entering the office. You can ask employees whether they have been exposed to anyone who had COVID, but you want to be aware of GINA, the Genetic Information Non-Discrimination Act, right? That act prohibits employers from asking employees medical questions specifically about their family members. So you can say, has anyone, been exposed to any family members? You could say, has anyone been exposed to the coronavirus, but you can't ask if their family members have or had COVID. Finally, two finalies. Second to last, you can require employees to tell you if they have COVID, and you can ask if employees are experiencing symptoms. And you have the right to send employees home if they're displaying symptoms.
All right. So we've just asked a ton of questions, and we've probably gotten a ton of medical information back from our employees. So this goes to Simone. Amy mentioned HIPAA. Let's dispel some myths about HIPAA when it comes to getting this type of information from employees. Where does HIPAA apply and where doesn't HIPAA apply?
Sure, be glad to answer that. So HIPAA applies, HIPAA is the federal law, the Health Insurance Portability and Accountability Act, that applies to very defined covered entities. Usually an employer is not a covered entity. And it is designed to protect health information, which we also call PHI. So typically, any information that is shared with an employer by the individual would not be something that we have to be concerned about from the HIPAA perspective. However, it is medical information, and medical information is often protected by other statutes, and some of them we've already mentioned. There's certainly also state statutes that may define personal information to include medical information about an individual. So I would broadly say, if as an employer we may not be concerned about HIPAA, we should be concerned about the receipt of medical information generally. And what statutes or laws are implicated may vary from state to state. and it may vary from the situation, which has to do with the source and what kind of information it is. But we already mentioned some laws that may be implicated, and that could be OSHA, that could be the ADA, that could be GINA, different laws that might apply, and that all have some restrictions on how we treat medical information. So I would view it more broadly as medical information. There should be a pause, and we need to think about how we're going to treat that information we just received.
We're getting questions already, and I'll try to kind of intersperse them as they, if they're germane to where we're at in our agenda. And here's one. I don't know if we're equipped to answer this, any of us, because none of us, I think, are licensed to practice in Florida. But there is a question that was asked about vaccinations in Florida. Can you ask about vaccinations in Florida under its Privacy Act, which this person thinks is more restricted than HIPAA? Anybody have a thought on that one way or another? I'll pass. I'll say I'm not licensed to practice in Florida. I don't know.
I mean, I can try to answer the question. Generally, I believe you will be able to ask the question. The question is, how do you treat the information received? And it is subject to confidential treatment. So that may mean that you not record it and return it to the employee, and record only in your files that the employee is clear to return to work. Or you create a separate file for the employee. Generally, under the privacy laws, and I'll just speak generally under the privacy laws in the 50 states in the United States, the focus is on securing that information. So there may be security laws that may apply, or there are breach notification laws. So if this information were accessed by an unauthorized individual, then you would have to take certain steps of letting that individual know.
Okay. So along the lines of what we've been talking about with COVID-19 and getting information about folks that either have COVID-19, have symptoms of COVID-19, or have been exposed to someone who has COVID-19. Contact tracing, okay? We've all become somewhat expert on contact tracing. At least I think we have. Probably a lot of people on this Zoom have become experts on contact tracing, which 2 years ago, oh my God, like what are we talking about? But let's go through that one more time, and I'll pitch this one to Amy. So contact tracing. What are some of the do's and don'ts when someone says to you, I'm suffering symptoms, or I came into close contact with so-and-so who developed COVID-19?
So that's a great question, and one we're asked so often about how to do the contact tracing and what kind of information to convey to employees. I mean, when you should communicate with your employees if COVID has been present in the workplace, and you have to connect with people who've been exposed by a coworker who tested positive. You cannot reveal the person's identity. That is the issue. Even if everyone knows that it can only be Larry, right? Even if everybody knows that, you cannot reveal the person's identity. What we like to say is use a generic descriptor, such as telling employees that someone at this location, someone on the 4th floor, someone, at the south end of the suite tested positive for COVID. That provides notice without violating the ADA's prohibition of disclosure of confidential medical information, and I suspect HIPAA's as well. We recommend that employers really explain that as a policy. I think vaccine policies are so important, and COVID policies in your workplace are so important to set clear expectations and guidance. And I know it changes, and we don't like to amend policies once we to have that policy to tell your employees that, hey, when we learn someone has tested positive, we will determine whether other employees have had close or direct contact with the confirmed positive employee within the last 14 days. will alert those employees and direct them to stay out of the office for 14 days from the last close or direct contact with the confirmed case. Close contact is really defined as 6 feet for a cumulative total of 15 minutes or more over a 24-hour period. Walking past someone in the hall, and I get this question all the time, is not close contact, right? If you're walking past somebody, 2 minutes here, 2 minutes there, that's less likely to be close contact. You want to talk to these people who've been in close contact and send them home or instruct them not to come into the office. So you just want to keep the one thing clear as to not identify the coworker in question. And different states with different OSHA standards, can differ, right, from this CDC guidance. Part of the New York OSHA reopening workplaces guidance says if a worker tests positive for COVID-19, you must immediately notify state and local health departments and cooperate with contact tracing efforts, including notifying potential contacts like workers or visitors who had close contact, maintaining confidentiality required by state and federal law while doing the contact tracing, and maybe, and I love this idea, designating a contact person, one person who will notify people that they may have been exposed to COVID.
Simone, someone just asked, and piggybacking on what Amy just said, we do close contact tracing. We're very careful not to identify the employee who may have been in close contact with someone who has COVID or someone who has developed COVID symptoms. What if that employee gives permission to reveal their name? Can you do it?
I would follow a general policy of not to do it because you want to have a uniform approach. So I would just adhere to the not disclosing the individual. You can contact trace without doing so and follow your own policy. Likely, what we have done during the pandemic is create a memorandum that we send to all employees about what we would do. And it's always good to be consistent in your approach. Also treat every employee the same. And it gets fuzzy when one person supposedly gives consent and another doesn't. I would it's not necessary for the contact tracing to do so. And I will say that sometimes employees don't understand what our requirements are and that we do treat the information confidentially. Also California has a law that requires notification of all potentially affected employees that may have been exposed to COVID-19. And, that does not mean that you have to identify, Susie has COVID by a blast email to the entire office or plant, what have you. That's not what that means. What that means is that we first sit down with Susie, identify who are potentially exposed individuals, and then we go to those individuals. We can maybe cross-reference, ask them who they were in contact with, and then take appropriate action. So no, I would not.
Hey, what if I have a question? I get to take a place for a minute. What if
it depends.
I love it. What if before you can contact trace, what if an employee sends out an email saying, hey, I'm going home, I've been diagnosed with COVID. So the employee themselves spills that to all the other employees.
He or she is fired. No, that's I'll defer to Simone on that one. Go ahead.
I mean, certainly they have a right to communicate that, and obviously it's done. That does not mean that we need to confirm it on the back end. What we will do, of course, then sit down with Susie that has just sent that blast email herself. We'll talk with her and we'll take those steps. Just because she said that, we still need to follow our own verification protocol with her. Once, she's identified it or spelled it out more in detail, we'll take the appropriate steps. And irrespective of what Susie did and how many people Susie voluntarily shared this information with, we should just stick to our protocol.
But that becomes a medical record, does it not? If Susie sends out a blast email that says, I have COVID, no? What do you think?
No, I would not. It's not anything that a medical professional prepared. It's Susie's, it's Susie's communication at the end of the day. So that I would not say is a medical record.
how about something that would be a medical record, like temperature logs? So let's assume that as a prophylactic step each day, I come in, or maybe before I come in, I fill out, I go on my app and I say, look, I haven't been in close contact, I'm not suffering through any symptoms, haven't had COVID in the last 10 days, I'm good to go. And then the last line of defense when I get to the front desk or wherever is someone zaps me in the head to take my temperature to confirm that I'm below 100.4. Okay. What should the employer be doing with that information, if anything?
So my suggestion would be to not record it, because all the employer is trying to do is to ensure safety, right? To create a safe work environment. And once that employee or a vendor shows at the door, we have a safety protocol in place. It does not require us to record the temperature. In fact, the question is, would that go too far? And if we record it, certainly we would want to keep that separate as a medical record. But my suggestion would be to not record it. We can just record that on that day we had, 20 employees or whatever the number is in the office, and, nobody had a temperature. That's maybe something we want to record, but that's, once you specify an individual, you identify them by name, and you record something that is specific. I mean, body temperature does provide information and it can be deemed medical. You get into some confidentiality and privacy issues. I think that can be avoided. Amy, I'm curious about what you think about that.
I mean, I generally agree with you, and it's consistent with guidance that we provided previously back in January. I teamed up with some members of our privacy team, which I wanted to introduce you to in your second week, to talk about those things. Not recording is definitely, especially if there's no reason for it. Nobody needs to hang on to these logs.
Mm-hmm. And I'll actually add to that, generally from a privacy perspective, the less you record, the better, because you're generating data. And then you have to consider or be concerned about, well, what kind of record did I just create? Where does it need to be kept? Is that a record that is now in a medical file separate from the employee file? What laws apply to that? What do I have to think about in terms of retention, document retention policy that may apply? So, the keep it simple rule would be, generate less data, then you have to worry about that. From a business operations standpoint, what you're concerned with is it a safe workplace? And you're putting those things in place, but you may not need to record the specifics, just the conclusion.
And piggybacking on Simone's point, and the more data you keep, the more data you might have to keep for a long time. I mean, under OSHA, for example, if you have a workplace incident and there is medical data that relates to it, you're keeping that for the tenure of the employee plus 30 years, correct? It's a long time to have to hold on to that data. So less is more. Before I want to steer into privacy issues with employer-sponsored vaccinations, because that's becoming a thing, right? That employers are going to have, whether on-site or off-site, they're going to have vaccination clinics, just like we did with flu, to get employees vaccinated. But before I get to that, there was a great question that I want to answer. This is from Kathleen, and she noted, it's not really a question, it's a comment, but I'll put it out there for Amy and Simone. She notes, we have had issues with employees posting information on Facebook. So how about the employees talking about COVID issues on social media? And I have some thoughts, but I'll defer to the two of you first. Simone, you gave the what do you think?
Social media, big sigh, right? Social media can become problematic for an employer, and I would say generally you want to think through what you want employees to do. with regard to social media posting about the workplace. Some employers have social media policies as part of their handbook and part of their expectations, simply because, photographs talking about work situations, worse derogatory, or defamatory information about the workplace, obviously we need to control. Similarly to COVID, I could imagine somebody posting about, Susie, going back to Susie and her COVID outbreak. Susie has COVID, about the workplace. So I would put that in the general context of how do we direct and coach employees about their posting on social media as it relates to the workplace, not their private lives, which is fine, but their workplaces. That's how I would generally view it, and that's where my sigh was, because generally we all know in this field that social media posting can be problematic.
What do you think, Amy?
Matter with what your policies say, and it's prepared to deal with the issues that, of where we are, which is in the time of social media and everything is really out there, and you have to be very clear with your policies and what is going to be an issue in your workplace.
Yeah, I think about the National Labor Relations Act and protected concerted activity, right? So you have one person who gets on social media and says, so-and-so has COVID. And then on top of that, they say they probably have COVID because we haven't been socially distancing. The masks are a problem. We're not getting enough masks. And then someone else chimes in and says, yeah, you're exactly right. I had an issue the other day in the break room where we were within 2 feet of each other. A manager reads this and gets, all hot and bothered about it. And you want to discipline these people, but they've probably engaged in protected concerted activity under Section 7 of the National Labor Relations Act. So you have to be careful about that. If you're in the private sector, whether you have a union workplace or not, more likely than not, you're probably covered under the National Labor Relations Act. And if you are disciplining employees who are discussing working conditions together in an effort to improve them. So the classic example is talking about salaries. We're not paid enough. Yeah, we're not paid enough. Boom, protected concerted activity. We should get a raise. Protected concerted activity. So when people are talking about these issues online, that can be protected and concerted activity. So part of the solution is communicating to your employees that, look, we're not telling you can't go on Facebook and talk about the workplace. We don't want you sharing confidential medical. We don't want you sharing medical information about your coworkers. But if you have issues, come to us. Let us try and address them directly rather than just broadcasting them on social media. That's not going to be as effective in getting your problems resolved. Please let us know what your issues are, and we'll address them. And the other thing too is, under many state whistleblower laws, you discipline someone or you fire someone for posting on social media about how you're not masking or how you're not maintaining a safe workplace. I know in Jersey, for example, you just bit off a claim under the Conscientious Employee Protection Act. So one of the most employee-friendly whistleblower laws in the country. So that's something to consider there. Let's pivot away from social media, because we could really slip into a vortex there. And let's talk about those employer-sponsored vaccination programs. Simone, what are some of the things that employers should be thinking about when setting up a vaccination program?
And that's a great question. I just want to point out, Amy and some colleagues wrote a great piece or great blog about this issue. There are a multitude of issues, certainly with setting up your own vaccination program. And number one, I think the question is, or should it be voluntary? And I think, our consensus is that we want to encourage and incentivize employees in participating in that program. rather than mandate it. There was new litigation that just came out of Los Angeles. It's, I believe, the school district teachers sued for or against a vaccination mandate that had been imposed on them on the basis that they said these drugs that have been admitted under the Emergency Use, what's it called, Emergency Use Act, is really experimental, and therefore a requirement that they be vaccinated is a human rights violation, which is a very different and interesting angle. The better path probably is to make it voluntary and incentivize it by, generous, making it easy. So on premises, if you're already a health care provider, then that's probably easier to do. If that's not your line of business, then there's some additional wrinkles in having medical professionals come to the site and provide that as an option to employees. I would definitely, make sure that, you don't have unintended liability exposure. So you want to make sure that is something that is both supported by your insurer with regard to what you're offering, and two is that you vet the vendor, right? These are medical professionals that provide it. I would also suggest that you not require access to the information that the medical providers obtain, because that can create a whole separate host of issues that have to do with, can you ask about medical conditions? And I think the easiest way to tackle that is to allow the medical professionals to provide this as a service, but that the information is not shared with the employer. Instead, I would suggest that you allow the employee to share with you that they've been vaccinated, which generally is sufficient information for your purposes, but you don't need anything beyond that. You may want to think about consent forms that you have, and generally I would insulate, if I were the employer, I would insulate myself from any responsibility with regard to and or any promises about the vaccines, which obviously the employer shouldn't vouch for.
Aim, do you need me to turn on your video for the other one?
Yeah.
Okay. Bear with me 1 second, folks. Sorry about that.
There we go.
All right. See you, Amy.
Yes, I was in transition to my phone. And the CDC put out guidance on this issue as well, which has been really instructive on the employer getting a third party to provide the vaccines. So if we didn't touch on that yet, I think that's so important to check out that CDC guidance on testing and seeking informed consent to do so.
Right, go ahead, yeah.
Okay, I just want to make sure I didn't miss it. In the transition from computer to phone, I mean, as we know, testing, even if mandatory, can be used as part of an employer's COVID prevention plan. But what we recommend, and I think that's in the blog that Simone was referencing, with the privacy group, you want to do this with informed consent. And the CDC has recognized that as well and set forth certain requirements for informed consent, including disclosure, and the idea is really so that an employee has a free choice to make an independent, voluntary decision about the vaccines. The CD recommends to ensure consent for a testing program, to provide complete, understandable information about how an employer's testing program may impact an employee's lives. such as if there's a positive test result or they decline to participate in testing, if that may mean exclusion from work. And I think that makes sense, because what we've said all along, we're talking about mandatory versus incentivizing employees, is education. You have that 20% of employees who are really on the fence. Am I going to get vaccinated or not? When you educate people, when you give them information, you're going to make it a lot more likely that people in your workplace get vaccinated.
Yep.
The CDC talks about explaining any parts of the testing program that an employee would consider especially important when deciding whether to participate, providing information about the testing program in the employee's preferred language. People speaking several different languages. It should also be it should be readable. It shouldn't be 10 single-spaced pages of your vaccine policy. And the CDC has a tool that Eric can provide you in the chat below in order to create clear messages to your employees, educating them as to why they should, educating them about the vaccination process. You want to encourage supervisors and managers not to pressure employees. And you want to encourage people to answer questions. That open door policy everybody likes to put into their handbooks, right? We're an open book and you can come talk to us anytime. That really facilitates understanding and promotes the free choice that we want with a vaccine policy in the workplace.
Mm-hmm.
So this doesn't take away an employer's ability to be able to discipline the employee appropriately. You can, but I do recommend, and the CDC recommends, and I'll let Simone speak for herself, since we're just getting to know each other, that you want to give advance notice to your employees of the consequences of refusing to consent to COVID testing, and talk to your legal counsel about that and what kind of message you want to convey and what are the legal implications of that, both from an employment and a privacy standpoint.
And folks, I'm going to follow that Los Angeles case that Simone mentioned involving the Los Angeles Unified Public School System. And there's another case pending in New Mexico where a current employee claimed that a detention center, another public employer, should not be permitted to force employees to get vaccinated. Now, that employer had exceptions for someone who has a disability under the ADA or a sincerely held belief against getting vaccinated, but everyone else needed to get vaccinated. So that individual sought an injunction, and I will keep you folks updated on the blog as to the outcome of those cases, because they could be dispositive as to whether you can actually require employees to get vaccinated. Although anecdotally, really the workplaces I see where employers are requiring vaccinations are generally in the healthcare setting, and that's pretty much it.
And senior living.
And senior living, correct.
Senior living.
Yeah. Assisted living. That's a lot of questions we're getting as well.
Yeah.
But for the reasons we've discussed, right? It's fraught with legal issues, right? It's really uncharted territory. And beyond that, there's this sense of, you're imposing yourself on someone's free will, right? You don't want to create a morale issue. You want to give people the opportunity to decide for themselves whether to get vaccinated. You hope people make the right choice and get vaccinated. But the idea of saying to someone, hey, you have to get vaccinated in order to work here, that may not come off the right way to everyone. And you risk creating a lot of tension in your workplace. So
yeah, we talk about that all the time. Just because you can do something doesn't mean that you should. And what you also have to think about the implications. Say 30% of your workforce has no intention to get vaccinated. Are you going to fire 30% of your workforce? Which is where that education and incentivization kind of program comes in.
I would. I'm cold as ice. I'm a creep. I would do that. But.
And it's interesting because some, employers in these areas, so it's healthcare, school districts similarly, right, are tackling with this because they're in the front line. They will have the students come back. That's how most states are making the push to go back. And some make the decision to mandate vaccinations, some do not. Generally, I want to just remind us all that there are exemptions to a vaccination mandate, and those would include any religious exemptions, any medical exemptions, and you generally have to be mindful of that. Overall, and I think you raise a very good point, and if you have the stick approach, what effect does that have on morale? Is perhaps the carrot approach the better tool that also is not only for the long-term goal of making everybody safe or keeping everybody safe, but also long-term relationship that you have with your employees. If you have, issues with retentions or recruiting because you're in the medical field and there's just scarcity of talent, then you may want to think about that too.
Right, and you have, don't forget about the glass door effect.
Mm-hmm.
Right, you're going to have you potentially have reputational damage, when your employees going on Glassdoor or Indeed and talking about the approach taken.
Mm-hmm.
Well, folks, we've got about 18 minutes left in this session, and I want to take advantage of the fact that we have a cyber data privacy expert here. Simone, I'm going to flip this to you. With COVID, with COVID and more people working remotely, we have this increased risk of data breaches, right? Employees falling prey to phishing, malware, you name it. I mean, I'm guessing you're pretty busy right now. Can you give some tips for this HR audience as to kind of some best practices, pitfalls to avoid when it comes to remote work and the potential for data breaches?
Sure, and you're absolutely right. So there's been this absolute increase, drastic increase since the pandemic started last year in cyber attacks. And the reason is, of course, that as far as the workforce, we pivoted from in the office, where we provide a more secure environment, to work from home from one day to the next, pretty much. And we weren't exactly, as businesses, we weren't exactly prepared to keep the same security measures. So there was a decrease in the security protocols that we were able to have with the employee working remotely, and that certainly contributed to the spike. Also, there was just a spike as far as the increase of the attacks, because many people in the home environment let their guard down for whatever reason. That's more a psychological reason than anything else. In the office environment, they are maybe less prone to click on that phishing email, but in the home environment, they're letting their guard down. So we saw a huge increase in two areas, particularly in ransomware attacks. And there have been some interesting changes in that as well, and in business email compromises. And both of those generally happen, the majority of those happen because somebody clicks on a link. And I'll just share with the audience generally that 70% of all data incidents, all data breaches, have a oops component where an employee is a weak link. So with that in mind, we know, and I implore all of you to focus on employee training, right? Because awareness is the first line of defense. It's not only all that fancy technology stuff. It is really that employee not clicking on that link, not falling prey to the phishing email. That is so, so important. So in the home environment, we had additional issues, and one was how the employee accesses the work environment. And oftentimes the access point was insecure, and so that added another layer of vulnerability that allowed potential, for compromise. Second is if the employee used home devices, so not company-sponsored devices that might be in encrypted or have, secure links, virtual private network connections to the work. They were going through an RDP portal, or they had some issue on their own home machine because everybody in the household was using it. So that just added much more vulnerabilities to the equation. So we've seen a huge increase. It's continuing. It's constantly evolving. And I would suggest to everyone on the call to invest some small amount in employee training.
Uh-oh. Looks like we got Simone frozen there for a second. And she was about to give like the best advice ever. Oh, she's off. Well, we'll get Simone back in a second. We can pick up where Simone left off. Amy, there were a couple of questions that folks wanted to address, with just pivoting back to COVID. And here's someone who asked, if we decide to voluntarily continue providing some of the types of FFCRA covered leave, but only due to the COVID testing, symptoms, quarantine, but exclude time for vaccinations, is there a risk to that, seeming like actively discouraging employees from getting them? Let's see. I don't know if I got that question right.
Oh,
Madeline, I started to read it. It made sense, and then it didn't make sense. Madeline, please re-ask your question in chat. I want to get to that.
The new regulations for FCRA leave provides two new bases to provide FCRA leave, right? Going to get a vaccine or recovering from the side effects of your vaccination. I don't know that I would decide not to provide one of those to employees. I know that, FCRA is a voluntary statute. It's a tax, credit statute. I don't know that you want to go one without the other. I think that it could very well create some disability discrimination issues, especially if you're not letting people recover. From a shot, because they vary so widely. And oftentimes when somebody has an underlying condition, you get more of a reaction. There's more of a reaction to the shot, and it takes people longer to recover.
I saw a couple of great, that answered the question. I saw a couple of great comments on the cyber security training. Kristen asked, do you recommend any employee training programs? And then John responded, we're required to do 45 minutes of individual cybersecurity training each year. We do before and after training. So over the last 3 years, our click rate, people clicking the link that shouldn't click, went from 53% to single digits. And he uses a company. I'm not going to promote them, but you can look at it in the comments. We do cybersecurity training as well as attorneys. We're required to do it each year, annual training. So I think that's a great way to do it. We have it run by.
Can I say something? It's really difficult. Like, it's not like your employees are dumb, and sophisticated. I had somebody hack into a doctor's email and have me open an Excel spreadsheet, and it was from a thread that I was on. Who would know that? Hackers are making it seem like they're clients and they want to, talk to you about something. These are sophisticated people. And I think to promote Simone's point, like we say with anything, the training, the awareness is so key of the most common types of hacks there are, and the most common types of malware, so that so your employees know what to look for, to maybe just think a second more before pressing, that oops moment.
Yeah, I think Simone logged back in. So if Simone's there, I'm going to let her, and only her, don't anyone else do this, turn on their video. I can see her name, but we'll see. If not, there she is.
I feel slightly better that I'm not the only one with technical difficulties.
Hey, anything can happen on the employer handbook office hours. This is the best. So perfect. Good to see you again, Simone. We wrapped it up. We covered everything there is to cover. No, Simone, we do have a question for you. question about, let's assume there's been a hack, right? So now we've taken our preventative steps, but oops, there's a hack. Someone falls prey to ransomware, malware, phishing, you name it. Just generally speaking, and HR might not be the point group for this, but just some general tips for HR. You've discovered a hack. What should you be doing?
Do we have another hour for this?
We've got 10 minutes.
No, I'm joking. The first thing you need to call is two people. One is an outside counsel who is called a breach coach. Somebody like myself or some of my colleagues here at the firm, because you want to have that first communication protected under and cloaked under the attorney-client privilege. The second call should go to the insurer that you might have. Hopefully you have cyber insurance, and they will greatly assist you in that process, and also connect you with additional resources. And then generally what happens is, with the assistance of outside counsel, what would be very helpful is if you have an incident response plan. An incident response plan is something that your business prepared to walk through certain scenarios and already have a pre-plan of what you will do in that event. So you will call the people involved, you create a team, and depending on the severity, you will involve those different individuals. You know, a business email compromise could be rather small in scale, not be operationally disabling. A ransomware attack, on the other hand, is an all hands on deck affair. You are not operable likely, and you need to get back up and running. So the ways you react to either of those scenarios may be very different. But with the assistance of an outside coach, you will then involve a forensics team. You will then determine what happened. You will determine if anybody had access to information that's confidential. And then that person will walk you through any requirements with regard to notifying consumers, your employees, anybody else affected, and regulators. Those are all the steps that you would walk through. If there's a notification required, they would co-author those with you or ghostwrite those with you and walk you through that process. You know, retain an outside call center, conduct the notification, and then walk you through that. And whatever happens next, they will be by your side and assist you in that process. So it is, you know, basically a full cycle event from the initial moment that you understand something is wrong, you assemble that internal team, you reach out to the outside sources until you back up and operational, until, you know, everything has been resolved and you're good to go moving forward, and you can put a report in the file and hope this will never happen again.
And fortunately, and the tie-in here today is we have folks who are working remotely, so that makes us more susceptible to these breaches. But fortunately, and I know this not because I stayed at a Holiday Inn Express last night, not because I'm a cyber expert, but because I talked to Simone in advance. Fortunately, the hackers aren't looking for an employee's COVID diagnosis. I mean, it's not something that you have to think about really in the context of, oh, I have this medical information or medical related information from employees. Like, this is what the hackers are after. That's not it. They're after social security numbers. They're after payroll information, bank data, stuff like that. So
absolutely, yeah. So generally, you know, that for anything that can be monetized or they want to extort, those two areas. So it could be a wire fraud scenario. So if you, for example, process any information with regard to a payment card, that could be subject. With regard to employee information, social security numbers have a value, so absolutely criminal actors are after those, and they will sell those on the dark web. Second, what we see is W-2 exploits, where, you know, somebody tries to obtain those W-2s and does fraudulent tax returns. And the third one is really where they redirect direct deposit information to a fraudulent account. When that happens with a retirement account, that's a big sum that can be gone. So that's something to look out for. So always have some verification steps in your procedures to make sure that any change request is in fact legitimate.
Excellent. Well, we've got 5 minutes left, folks. I think what I'd like to do in the final 5 minutes is answer some questions. So if folks have them, throw them in the chat window. I'm just going to scroll through and see what we have. Here's someone, Justin asks, we have encouraged our employees who are all currently eligible to schedule vaccinations on their own. Great. Can we inquire amongst the workforce about who has been vaccinated outside of employees that have made us aware? So could you send a email to everyone that says, let us know, have you been vaccinated? Yes, right? No issues there.
That's what we talked about in the very beginning.
Yeah.
Can you, if they
paying attention?
Yeah, whatever, slacker, back of the classroom. We ask, can you ask them if they've been vaccinated? Yes. Can you ask them if they're sick? Yes. I know Justin. I know you joined late. I know Justin. So that's okay. So yes, you absolutely can.
Let's see what other questions we have here. I'll ask Simone. Simone, we answered this with another audience member's response, but I'll ask you too. Do you have any recommended employee training programs on cybersecurity, cyber risk, stuff like that?
Absolutely. Feel free to email me. There's several, you can do it many different ways. You can do in-person specific training to your organization. You can always do that, and we're happy to help with that. But there are great programs out there where there are training modules, and many of them are specific to your business, because you might want to think about, well, I'm a financial institution. What are some specific things with regard to financial institutions, specific risks? If you're in the medical field, there might be certainly a lot of HIPAA training that's specifically geared towards some additional security features for employee vulnerabilities, the ones I mentioned, and there's some general training. So there are many outfits out there that have training modules that you can incorporate on for, let's say, a monthly basis. Where you require your employees to click on this, video that's only 10-15 minutes long, that's very succinct, not a lot of time out of their day, with some questions at the end to make sure that you just peak that awareness. Because as Amy mentioned, when I was trying to log on, I still have some technical difficulties, but I'm glad you can hear and see me. These are getting more sophisticated, and it's not static. It's changing by the month, the types of attacks, and they're very sophisticated. And oftentimes they research a particular business way in advance, and they have some very specific institutional knowledge, and sometimes use that in their spear phishing campaigns. So it is important to keep up, and therefore there are many great programs out there that if you email me, I'm happy to share those, whatever works best for you. And it's about increasing employee awareness and increasing our resilience to these attacks.
Great. Well, we're almost at the top of the hour, folks. I want to thank my guests, Simone McCormick, Amy Epstein, Gluck. I see two wonderful lawyers waiting in the waiting room who want to come in and tell everyone about COBRA. So hang around for that, I hope. But before, and Simone and Amy, you're welcome to hang around too. I'll turn your video off. I'm gonna put on Bob Ellerbrock and Mark Mathis in a second. But before I turn your video off and mute you, hello, Mom. Anything to plug? Anything to tell the audience before you go, Simone?
I'll stay healthy and safe. Thank you so much for tuning in.
All right, Amy, what do you have to tell everyone?
And ask.
All right. Well, everyone, we're going to take a 15-minute pause. You can hang out in the main room and hear Bob and Mark and I just talk about you all behind your backs. But otherwise, as we gear up for 1:15 is when we're going to get started with the COBRA session. And thanks, everyone. Those who are leaving, have a great weekend. I did remember to hit record. I am going to remember to hit pause here. So I can record the second session. But thanks, everyone. If you're watching this on YouTube, now's the time to hit like and subscribe and all that stuff. And for those who are staying, hang around. And for those who are leaving, have a great weekend.